evening to all of you friends. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So friends, today we are going to talk about and discuss certain important legal maxim. What do we understand by legal maxim? The term legal maxim means certain words aligned together means a particular principle of law. Okay. So there is a principle of law which gets in the form of 3 or 4 words. Act of God, voluntary non-fit injuriam, right? So there have been certain words which are primarily in Latin, some in French, some in other languages. Now these particular words, when they come together, they mean certain very important what? Principle of law. So today, in the course of this session, I'm going to discuss with you these important legal terms. Okay. So guys, let's get started. The first one, Actus de neminem injuriam. So what do we mean by this particular legal term? Okay. Okay, what do we mean by the term Actus de neminem injuriam? Can any one of you tell me? Okay, Asmita Singh says act of God causes legal injury to no one. Okay, okay. So absolutely, you got it absolutely right. You guys all got it absolutely right. It means an act of God causes injury to no one. Now, in case an act of God happens, it does not cause any injury to anyone, any legal injury, because it's called act of God. It's a defense. It's one of the defenses in law of torts. It means an act is caused by the effect of nature without any human interference, and it is called act of God. So an act of God prejudices no one. This is very important for all of you to understand. The law does not hold a man to a legal duty where he is prevented from performing it by an act of God. Am I clear, everyone? Okay. Moving on. Question number 2. Caveat vendetta. What do you mean by the term caveat vendetta? Okay. Caveat vendetta, very good. It means let the seller beware. The person who is selling the goods, now in a contract, now when we are talking about law of contract, there is agreement, there is buying and selling of goods and commodities, right? So caveat vendetta is a particular term which means that the person who is selling the goods or the services must be aware of what he or she is selling. Am I clear, everyone? The person who is selling the things must be aware and beware of what he is selling, right? Let the seller beware. The seller is accountable to disclose every required information to the buyer of the goods. So the buyer of the goods have a right to know what he is buying. Similarly, the seller of the goods has a duty to inform the buyer about the required information relating to that goods. Is that clear? Okay. Moving on. Question number 3. Ab initio. What do you mean by the term ab initio? It's a very easy one. It's a very, very easy one. Okay. There are certain contracts which are void ab initio. Right? If the consideration is illegal, if the object is illegal, right? So there are certain agreements which do not become a contract. Made by a minor, illegal consideration, illegal object, stuff like that. So what do we mean by ab initio? Very good. Option C, from the beginning. It means from the very beginning, the agreement is not a contract. It is not a contract. It is not enforceable by law. Am I clear, everyone? Am I clear to each and every one of you? Please tell me that. Very good. Very good. Right. Brilliant. Brilliant. Fantastic. Great. Okay. So it means from the beginning, from the inception. Now, I give you that example of an agreement, right? An agreement is considered to be void ab initio if at any point in time. That means there are certain possibilities wherein an agreement is void because there is illegal consideration, illegal object, stuff like that. Right? So it means a void from the very beginning. From the very birth of the contract, it is void. Right? Okay. For example, to do an impossible act. Suppose I say, I'll give you 100 rupees the day the sun rises from the west. It is impossible. An agreement with an insane person who is suffering from unsoundness of mind. Right? Fantastic. Fantastic. Let's go ahead. Question number 4. Consensus ad idem. What do you mean by the term consensus ad idem? Now, when we enter into a contract, both the parties to a contract must be aware of the terms and conditions of the contract. So, when I enter into a contract or when you enter into a contract with someone, you must be absolutely clear about the terms and condition of the contract, and I as a seller of a good will also be absolutely clear about the terms and condition of a contract. Consensus ad idem means meeting of the minds. Am I clear? It means meeting of the minds. Am I clear to each and every one of you? Am I clear to each and every one? Okay. Please read this. Consensus ad idem. What does it mean? Meeting of the minds. In any valid contract, there must be meeting of the minds of both the parties. Now, consensus ad idem happens to be the most essential condition for a valid contract. I must know what I am buying. You must know what you are selling. When both the two parties who have sufficient knowledge about the goods that they are transacting, only there is certainty of meaning and consensus ad idem. Right? Is that clear? Please read this example. Everything will be clear to each and every one of you. Okay, all of you? Am I clear? Fantastic. Moving on. The next question. Res ipsa loquitur. What do you mean by res ipsa loquitur? Reason for deciding the main part of judgment. A case which has already been decided. The thing speaks for itself. Voice of the people. Which of the following is the correct answer? And the correct answer is option C, things that speaks for itself. Okay, things that speaks for itself. Very good. It means that, for example, in negligence, the doctrine of law states that a person is presumed to be negligent if he or she had absolute control over whatever caused the injury. So, this is a doctrine of law which categorically states that a person is presumed to be negligent if he had control over the event which has caused the injury. Am I clear, everyone? Okay. Question number 6. Quid pro quo. What do you mean by quid pro quo? What do you essentially understand by the term quid pro quo? It means something for something. I give you something, you give me something in return. Quid pro quo means consideration, something for something. Okay, it means something for something. Okay, let's try to understand this. It is used to describe a situation where two parties engage in a mutual agreement to exchange goods or services, something which is close to what we had called the barter system. Okay, so I give you 1 kilo of rice and you give me half a kilo of dal, right? Something I give, you give something, right? Am I clear, everyone? Okay, brilliant. Question number 7. Okay, what do you mean by lex talionis? Lex talionis, please. You guys are doing a wonderful job. I am getting absolutely great answers from each and every one of you. Okay, fantastic, great. Lex talionis means the law of retributive justice. An eye for an eye. Now, an eye for an eye is the concept of retributive justice. Now, retributive justice simply refers to the fact that where, suppose a person has killed someone, will you allow the other person's family to kill a member of this family? No. So the principle of retributive justice is an eye for an eye. Okay, an eye for an eye. Okay, now an eye for an eye, a tooth for a tooth is what we understand by retributive justice. Okay, but in India we have the kind of justice system we have insofar as criminal law is concerned is the reformative justice system. We are trying to reform those people who are in conflict with law, who has committed some crime, right? Okay, moving ahead. Question number 8. Question number 8, malafide. What do you mean by malafide? A good faith, in utmost good faith, bad faith, men with faith. Okay. 8. What do you mean by malafide? I'm sure that you must have definitely heard somebody, he has some bad intention, he has some malafides. Malafide means bad faith. Very good. In bad faith. Okay. Bona fide means in good faith. Bona fide. But malafide means in bad faith. Is that clear? Is that clear, everyone? Now, it is used to indicate bad faith or bad intention, guilty mind. Okay. The term called guilty mind. You must all understand this. Malafide act is something like a wrongful act. You have committed something with malice in your mind, with a guilty mind. Correct. Okay. Question number 9. Actio personalis mortu cum persona. What does it mean? moritur cum persona means, after the death of a man, after the death. Action, personalis. It simply means a personal right of action dies with the person. Now, suppose there is a dispute, a civil dispute between Mr. A and Mr. B. Suppose Mr. A and Mr. B has filed a defamation case against each other. Now, if Mr. A dies, the case collapses. The right to action dies with the person. That is what is stated. Am I clear, everyone? Am I clear? All of you. Okay. Very, very important. Okay. A personal right of action dies with a person. Now, this is applicable in case of civil wrong. Is that clear? Please read it carefully. Read it carefully, all of you. So guys, if you are watching this session, do press the like button, okay? If you do not press the like button, it's not the correct way, okay? If you are liking this session, do press it, okay? And guys, do share this session because these sessions are meant for people who cannot, come to us, or there are certain difficulties with them. We are providing you guys with these sessions, okay? So do spread this news that there are free classes going on YouTube by BYJU'S Exam Prep, which anybody under the sun without paying even a single penny can join and take advantage of these free sessions. Okay. Okay, moving on to question number 10. Actus curiae neminem gravebit. Actus curiae neminem gravebit. What do you mean by actus curiae neminem gravebit? Anyone? Okay. It means an act of the court shall prejudice no one. If a court is deciding on a particular issue or is giving a particular judgment, it does not prejudice or cause any kind of prejudice to any person. That is the law. If the judgment of a court and action of a court cannot prejudice anyone. Okay. Acts of court shall prejudice no one. This maxim advocates that a law court or a judge should be neutral while hearing the sides of the case. He must not have any preconceived notion about any of the parties to the case. Okay. So that is what we mean by that, the fact that the action of a court should not cause inconvenience to anyone. Okay. Okay. Question number 11. Audi alter partem. What do you mean, or what do we rather understand by Audi alter partem? Audi means, I'm sure you guys know it, auditorium, right? Audio and visual. That means it has something to do with speaking, right? Audi, hearing. Alter, alteram means alter. Partem means party. Hear the other side. Now, it's a principle of natural justice. It's one of the most important principle of natural justice, which says that when a judge is deciding a case, he must hear both the sides. He must give opportunity. To to both the sides to present their cases. Am I clear? So when a judge is deciding a case, he does not say that I'm only going to hear only one party and decide. No, he gives opportunity to both the sides of the party. He gives opportunity to both the sides of the party to present their case. Okay, that is what we mean by audi alter partem. No person shall be condemned, punished by a court of law without being heard. Okay, without being heard. Very, very important. Okay, so let's see the answer. Yeah, no person shall be condemned, punished by a court without being heard. It's a principle of natural justice that both parties shall be heard appropriately before passing any judgment or any order. Am I clear to each and every one? Have I made myself clear sufficiently to each and every one of you? Okay. Okay, fantastic. Great, great, great. Okay, moving on. Moving on. Actus rea. What do you mean by actus rea? What do you mean by actus rea? Tell me. The word actus rea comes in criminal law, which essentially says that both mens rea and actus rea is required. Both mens rea and actus rea is required for the commission of a crime. So for a crime to take place, for an action to be called a crime, there must be both mens rea and actus rea. Is that clear, everyone? Am I clear to everyone? Please tell me. So, for a crime to take place, there must be a guilty mind. In addition to the guilty mind, there must be a guilty action. Right, all of you. So, what is the correct answer to question number 12? A deed, a guilty action, a guilty deed, a guilty action, a wrongful act. That is what we understand by actus rea. Please read it. It is commonly defined as a criminal act that was the result of voluntary bodily movement. This describes a physical activity that harms another person. So it deals with the physical activity that causes injury to another person, that causes harm to another person, that causes damage to someone's property or his reputation. Okay, so both mens rea, that is the mental element, and actus rea, that is the physical element, are absolutely required for a crime to take place. Okay, okay, moving on. Question number 13, non-obstante. What do you mean by non-obstante? The word non-obstante means notwithstanding. This is very, very important. Option D, very good, very good. It means, now, without anything contained in the law, this is going to happen insofar as a contract with child is concerned. There can be laws. There can be laws, special laws meant for the woman, for the children and all. The general law is this, but nothing withstanding will be applicable for children and women. There can be, right? Which means is used upon clauses that empower the legislation of a provision which is contained to override the effect of other legal provisions. So if you want to override the other provision for a specific category of people, you can do it by the use of non-obstante, by the use of the word non-obstante. Okay, all of you? Brilliant. Moving on to question number 14. Damnum sine injuria. What do you mean by damnum sine injuria? Anyone? Fast. What do you understand by damnum sine injuria? Okay. Damage without injury. Okay. There is a loss without violation of a legal right. Gloucester Grammar School case. The famous case of Gloucester Grammar School, wherein a new school was constructed or created next to an old school, and which resulted in a lot of loss, financial loss for the old school. The courts held that what? That there is no legal injury. You might have suffered some losses, but there is no legal injury, right? So the correct answer over here is option B. Okay. So you have damnum sine injuria and injuria sine damno. Okay. All of you, everyone. Okay. All of you. Okay, okay, fantastic. Great to see, great to see. Okay, moving on. Question number 15, res integra. What do you mean by res integra? Okay. First, what do you mean by res integra? It means an entire thing, okay? That is what we mean by res integra, okay? Res integra simply means an entire thing. Let's see. It is applied to those points of law which has not been decided. Now, there are certain issues, there are certain laws, there are certain things that have till date not been decided. For example, the Citizenship Amendment Act, whether it is legal or whether it is illegal, it is pending before the Supreme Court of India. The Kashmir, the bifurcation of Jammu and Kashmir, the erstwhile state of Jammu and Kashmir, into two union territories, and the abrogation of Article 370. Now, these are matters which have not been decided by the courts. These are untouched. Now, these points have to be decided later. Someday or the other, these things will be decided. So, res integra are those issues that have not been decided. Am I clear to each and every one? Have I made myself clear to all of you? Did you all understand? Tell me. Okay, all of you? Any doubts? Okay, brilliant, brilliant. Great to see that, great to see that. So guys, with this, we come to a conclusion, but this class is not yet over. Now guys, Since you guys are preparing for CLAT and other law entrance examination, just 2 more minutes, Since you guys are preparing for CLAT and other law entrance examination, understanding these important legal maxims, is important. Now, how do you remember these legal maxims? Now, you can remember these legal maxims if you use them. The moment you start using them in your language, when you are speaking, it is no more res integra, right? It has not been decided till now, right? So, all that I'm trying to say is the fact that you guys have to get into a habit. You have to get into a habit of understanding these important legal terms, get into the habit of reading them, practice them, and then use it in your vocabulary. Okay. Yeah, how many legal maxims are completed? I think there are 15 today. I have discussed 15 today, Neha. Okay. So guys, with this, we come to the end of this session. Thank you very, very much. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy, and definitely do not stop preparing. Okay. Thank you. Bye-bye. Take care. Have a great evening. Have a great week ahead. Thank you.